Welcome once again to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program was created to educate, inform, and help you with law matters because the law matters. A better understanding of the law puts you in a better position to decide how to protect yourself, your family, and at times your business with all things regarding the law. In each segment, we try to provide information and resources that'll help you decide whether or not you actually even need to contact a lawyer. Perhaps you'll be able to handle some issues yourself. If you do decide to contact a professional, our goal is to help you be better prepared, also to help your professional counsel be better prepared, and to save you time, money, and always to achieve the best possible results. Also, as always, we want to thank the Bizarre & Associates law firm in East Providence, who continues to help us, and we want to, as always, welcome David Bizarre, our attorney and legal eagle, who weighs in on the topics that we present. And while we are speaking to attorney David Bizarre, we are also, at this point, going to talk to David as a mediator, because our topic today is mediation, arbitration, and in some ways litigation when it's necessary. So the broad brush strokes is alternative dispute resolution, and it's about finding reasonable solutions, something that's with an acceptable outcome, maybe even something that approaches a win-win. Not always can that happen, but sometimes it can. And there are advantages to looking at mediation or arbitration versus full-out litigation. It's not supposed to be a weakness when people think about mediation, but rather just common sense, which should prevail. So one of the things that we can quickly say is that mediation is supposed to be less expensive than litigation, and it's supposed to be less time-consuming. And of course, there's the issue about how the courts work anyway. So it has plenty of uses, business and for families. Many of you perhaps know about divorce. But let's talk to our legal eagle and find out what is mediation, and then we'll talk about what the differences between the alternatives are. What's mediation, David?
Mediation, as you said, is a form of alternative dispute resolution. And what is it an alternative to? Litigation. So as you know, trials are expensive. They require the attorney to do a lot of preparation, sometimes requires expert witnesses and testimony from people that have to be subpoenaed to the courthouse to testify, and it can take a long time to get to the trial, to the courthouse, and it can be expensive. So if you're in litigation, many times the court rules require one form or another of alternative dispute resolution, of which mediation is one. And the difference, as you were starting to allude to, between mediation and arbitration is in mediation, you're before a mediator who hears both parties and tries to help you negotiate a settlement that's acceptable to both parties so that the case can be resolved. The mediator does not decide the case or put a figure on the case and say this is the answer, but rather helps negotiate the settlement.
So you point out that it's less time-consuming. I read something about, well, we know litigation can sometimes, at its worst, be years and a decade, and at times maybe mediation could be a matter of hours if people aren't adversarial, which I guess litigation by its definition is adversarial.
Right.
No matter how nice people want to be, it is contentious at best.
And that's part of the beauty, I would say, of mediation, because it can be used in several different types of cases. You raised a few at the very beginning: disputes between business partners, divorce, family court disputes, custody, family court disputes, litigation in superior court over personal injury or construction contracts or any types of litigation. It's also used in the sports world, as you know, in mediation or arbitration, either way of resolving disputes between players and their teams. Usually that's arbitration. But in any event, what happens is it's designed for people to start to talk to each other, and maybe through the mediator with each other. And I find it particularly helpful with a good mediator in family court. Because as you said, litigation is contentious. So if you go to family court and you have two people who don't want to be together anymore, there's probably already been a breakdown in communication. There may be some animus that has developed between the parties as things have gone along, and they've forgotten how to speak to each other. But oftentimes these people are going to be parents for a long time of children, and they need to learn how to speak to each other. And as a trained mediator, a good mediator, part of the goal isn't in family court mediation for a good mediator just to get the parties to a settlement, but it's also to help them create a framework to be able to speak to each other.
So that certainly can go a long way to ironing out some of the things that are happening at the moment and for the future. But I guess while we're talking about the divorce, and we can talk about business perhaps next, but when you think about it, if someone's decided that the marriage is no longer going to last, there's, as you said, hurt feelings, there's emotions. How do you know when someone walks in, David, I want to get a divorce, that person I can't be with it, whatever it is. How do you get to work with them? You're an attorney because they saw you as an attorney first. Maybe they didn't even know you were a mediator. How do you get to know who is likely to be calmed down, taken off the ledge, and able to sit and just have a reasonable conversation? How do you get to know that?
Yeah, so sometimes people will contact my office, not speak to me, but the office first about a divorce. And they'll often, the receptionist, whoever speaks to the people, will say, are you looking for an attorney for a divorce, or are you looking for to have your situation mediated? Because I can't represent a party to a divorce and then be the mediator.
Right.
And so if they call, that's what we figure out first. Do you want me as an attorney, or do you want me as a mediator? And if it's as a mediator, what I'll often do is ask both parties to come in together. You can talk to them alone as long as they know about it, but my preference is to talk to them together and determine whether or not they're going to be able to try to work towards a resolution together. That doesn't necessarily mean how close are they, or what the issues are. Really what it means is, do they have what I would call equal bargaining power? There's no issues about domestic violence between one or the other, or one party has more sway over the other party. You have to have an arm's length transaction, so you have to have people who can work towards a resolution with equal bargaining power.
So suppose whoever's calling you has already maybe worked with you in some other situation. Maybe you worked with the man or the woman first in a business situation, and now, okay, they call your office and say, here's the domestic situation here. Are you able to tell in that first meeting that, I don't know, say it's the man who you had worked with first in a business situation, and the woman maybe doesn't feel that she has the same kind of clout, strength. You know him better than you know. I mean, how do you work through all of those feelings? It would make sense that someone would reasonably say, you've never worked with me before, David. How can I know that you are objective? You already know more. How do you work through that?
So, frankly, if there's been a relationship with one or the other, I'll often just refer them to another mediator.
Okay.
Because you don't want to start with an issue that could be a conflict, or at least perceived as a conflict. Although mediators don't have to be lawyers, so they're not regulated by the disciplinary rules of attorneys. But I'm an attorney, so I'm regulated by the disciplinary rules of attorneys. So I'm not going to take something that is a conflict of interest, or even a perceived conflict of interest.
Even if it's unspoken. I was going to say, so suppose sometimes a person might confront it and be strong enough in character to say something, but others might have that unspoken objection or concern or whatever. So let's just finish up one other thing that you mentioned. So you are a lawyer and you could be a mediator. All lawyers can be mediators, not all mediators are lawyers.
Correct.
Correct?
Yes.
So at any law office where they're handling domestic issues, would every lawyer's office be able to say, hi, you're having a divorce, do you want it mediated, or do you want to have so-and-so serve as, will they all do that?
Not all attorneys, as you said, are mediators. And so they'll often ask if you, after they file suit or as it's moving along, recommend mediation and then send it to somebody else for mediation. So that will happen usually somewhere in the process. And so when someone comes to me, either referred to, together from another lawyer, or they found me as a mediator, I will sit and talk to them about the process. And what I tell folks in a family court mediation is the first thing you need to do is make sure there's full disclosure of all the assets. Everyone, you can't have the bank account in the Cayman Islands and not tell the spouse. It's not going to work. You can't have any hidden assets or anything that is being held back from one or the other. And then I'll explain the goal of mediation, which for me is to resolve the case, but also to get them to learn how to talk to each other again. And that really requires what I call active listening. You have to be able to listen and understand what the other party is saying. And so part of the routine that a mediator might do in a family court mediation is if the wife says something and you're watching the husband listen to what the wife says, and you're really sure they're not listening or paying attention or caring, I'll repeat it back to them. So your wife just said this, 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 and this. What do you think about that? And I'll make them answer that so that I know that they're actively listening. And at the end of the day, the hope is we resolved the issues of equitable distribution, child custody, parenting schedules, child support, alimony, or any other issues that may be involved in the breakup of the marriage, but that also, down the road, there's a framework for them to be able to speak to each other about, what are we going to do for the daughter's birthday? What are we going to do for the son's graduation? How are we going to work out special occasions or special holidays where something has come up? For example, I had a couple that were talking about what days of the week the husband should take the children for dinner, because they wanted him to spend time, quality time, not just 2 hours after school and go home, but go to dinner, do some things or some activities. And the wife wanted that, let's just say, to be on a Wednesday, and he wanted it to be on a Thursday. And so I'm trying to dig in on what's the difference for each of them. And what it turned out to be was he had a meeting every Thursday, perhaps. The wife thought the meeting was every Wednesday, and they hadn't talked it through to understand that they're actually on the same page. They just had their schedules mixed up. And so listen to each other, speak to each other, dig into what's the underlying issue so that you can resolve it. And if you can do that as a mediator in a family court case, you've taken that not only to a resolution of the divorce, but to a place where post the divorce, they should be in a much better place. So if they can't work it out, they'll be comfortable to come back to mediation to resolve an issue. I have
an example of a mediation situation which was very interesting too. I think I'm sure it's rare, but as you said, what are the issues? One starts to present what the issue was, and instead of the mediator saying to the other, well, I heard thus and such, what do you think about that? Instead, the mediator said, as if he was asking, do the verbatim, what did you hear her say? And when he was unable to even give a fraction of that story recounted with any accuracy, then the mediator got back involved and said, try this again, listen again. And after doing this for a couple of times, the session was just about over. Long story short, the couple was living under the same roof at the time, so they went back home and had whatever other discussions they were having with this same pattern of, she says this, he repeats this back, tries to do the verbatim. No, I didn't say that. Yes, you did. And after them having done this, what do you imagine? That the outcome wasn't that they were divvying up the assets, but instead they learned how to communicate with each other, and it diffused the whole reason that they decided to have a divorce in the first place. So I can't imagine that that happens often, but it was very interesting. And to your point, highlight the importance of active listening, understanding, and communicating effectively without people yelling, screaming, and walking away, or whatever other things that they do when they're unhappy with one another. It was a very interesting outcome.
Because oftentimes that's what happens is, especially in a family court situation, you just spiral down to a point where you're not even listening to each other anymore. So it's unusual that you're going to get to the level of a reconciliation.
Imagine that.
But it happens. I actually have told people, and I've seen this, that more often than not, you end up getting divorced, you don't reconcile, but I've had couples that have remarried because they've learned to get through and talk to each other again, and after the divorce and they're dealing with things, I've seen couples remarry. Again, not too often.
Yes.
But it happens.
So back to that process of mediation, David. So the couple comes in and you start to hear the story about this is what I would like, this is what I would like, and you're doing some facilitating. Are you also, so I hear that there are two different kinds of mediation, one that's facilitating and the other is evaluating or evaluative mediation, where you actually have to do some assigning of the gazintas and the figures. So mediation is not binding if you didn't get them to come to something that seemed reasonable by them talking together or with your help. What happens next? How does that play out?
Yeah, so mediation is non-binding. You're trying to bring the parties to a point where they resolve it. And if they can't, then they have to go to the next step, which either could be litigation or another form of alternative dispute resolution, arbitration. It could be binding arbitration instead of a trial. There's a number of ways to try to get it resolved beyond that, but mediation is not binding. So if the parties don't come to their own agreement, a mediator doesn't have authority to force an agreement. But to talk about the numbers and so forth, where numbers are more prone to be the issue is if you're mediating an auto accident, for example, a personal injury case, and the plaintiff thinks the case is worth, we'll make up numbers, $300,000, and the defendant thinks the case is worth $25,000. So the mediator's job is to try to bring them together. And unlike family court, where the mediator will be trying to help the parties resolve it by giving, like you said, evaluative, I think is the word you may have used. You're trying to evaluate the claim and so forth. In family court mediation, what I'm trying to do is show the parties what they have, because we put everything on the table, and what's a fair way to divide them up and let them figure that out. In a personal injury arbitration, oftentimes the mediator will give his opinion to one side or the other or both, back and forth, as to what the value of the case might be. And then you try to get them a little closer and closer. So what happens oftentimes in that type of mediation is you start together and then you separate the parties. And then the plaintiff will give you, well, I can prove this, 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 and this. And you go to the defendant and he'll say, I can prove this, this, and this, but don't share this, but I have this too. And so you're back and forth with numbers. And it's always, when I'm actually there as a party and not a mediator, I'm always trying to write down what their next step's going to be. I'm at this, where are they going to come back? And then if you're not there, but you're close, I've had mediators say, okay, here's what we're going to do. You started at 3, he was at 25, you're now at 150 and he's at 100. I'm going to write down 105, 110, 115, 120, 125, 130, what all the numbers, within increments are in between. And you circle the ones you would accept, the ones you might accept, and cross off the ones that are definitely not. And then the mediator will look at it and see if there's any overlap. If
there's a point of intersection. So how long could this go? So we say that it takes less time to mediate than it does to litigate. How do you know when you are at the impasse? These circles are so far apart, you're at an impasse, it's just not going to happen. How long will you play that game, deal with that, grapple with that, discuss with one, then the other, then both? How long can that possibly go on?
You'll take some time, even if you're somewhat apart. And depending on where it is and where the mediator thinks there needs to be a push, who's being too reticent about being reasonable, or in the mediator's perspective where the case should be, there's a lot of different things that you can bring to bear on that. One of the things you could do is pick a side. You get to pick the side. Who's off and who does the mediator need to prod in this personal injury liability litigation, the defendant or the plaintiff?
I'll be plaintiff.
Okay. So what you do with the plaintiff in that particular case is, first of all, what's the number, how far apart you are. And then you might explain to the plaintiff, if you go to trial, you're going to need to bring in your doctor, you're going to need to bring in this witness, you're going to need to litigate for X number of days with expenses, and here's what you can expect for expenses. And when you take those expenses off of where you're at, you're not that far apart. And so that's one thing. And then the other thing you would do is you'd say, what are your chances of getting this number, this number, or that number? And you try to give them a realistic impression of where their chances are of ending up at their number and what the difference is in their number and what it actually is once you take the expenses off. And you might be able to make some headway that way.
What happens if you are working with, as a mediator and you're asking about those numbers? I'm the plaintiff. Here it is, first and final. How do you mediate that? Is that just, no, we'll have to go to some other option? How do you deal with that?
No, so we've broken up, caucus, I think we might call that, and you're with the person and they say, this is going to be our first and final offer, and you'd say, nope, first of all, you're here to mediate in good faith. You don't come in with a final offer or first and best and last offer. This is a good starting point, but it's not your final offer. Otherwise, you haven't come in here in good faith.
And then what about the other that I hear is a terrible no. Ultimatum. If you don't do this, we're going to litigate. So what do you do to, again, take that person off the ledge? And obviously, that's certainly not good faith. Right. What do you do with that, David?
Yeah, the same thing. Why are we here? You agreed to come here. You wanted to resolve this case. There's reasons you want to resolve this case. And maybe you push back at why did they come in the first place and try to get them back to the common ground that you had to mediate in the first place. And if that's not going anywhere, then you just push them back on whatever, if it's a number, their number, the ultimatum. There are no ultimatums in mediation because it's a negotiation. It's not an ultimatum.
One other point I think that we didn't mention was about, with mediation, the conversation that you have with this one and the other, they remain private and confidential,
Yes.
Which if you change that scenario to, I don't know, what happens with arbitration? If it's litigation, all bets are off and everything is uncovered, so to speak, or supposed to be uncovered. How does that play out?
So there's two things. Like I said, you meet together, then you break up. I think we call that a caucus, and you meet with one side and then the other. And each side may share with you information that is confidential, that they don't want to share with the other side, but they're giving you a reason why you need to push them. It's kind of difficult sometimes. Well, you're telling me I can't share that.
I can't use that as leverage or
what
whatever.
Can I say? And so you try to get something. But yes, they can ask you to keep, and you do as a mediator have to keep the confidence of whatever the information that's being shared from the other side as part of where they're trying to get you to go with the next step with the other side. The mediation itself is confidential. You can't subpoena the mediator to court to come testify as to what happened because it's settlement negotiations are confidential. They're not admissible at a trial. Arbitration.
Good to know.
Arbitration, similarly, I think, is not the whole. This arbitration award was given, should not be an admissible number at a trial. It shouldn't be part of that. But what's not confidential is testimony that's given at an arbitration because the parties are sharing that. They're both in the room. And it's somewhat like a mini trial so that, if you're testifying and you're under oath, that could be used, especially if there's a transcript of the arbitration. So there's confidentiality in the award, I would believe, at least confidentiality in the fact that it's not admissible at a subsequent trial. But you're not confident, the information that's being shared isn't confidential because both parties are in the room.
Yes. So if you've had a successful mediation, the end product is what, and what happens if there's a breach of it?
All right. What kind of mediation?
Divorce mediation.
Okay.
We'll keep it easy because
So
we've been talking
what
about
happens with the divorce mediation is at the end of a successful mediation, the mediator generally will write up a memorandum of
that.
understanding.
MOU, okay.
An understanding between the parties of what they agreed to at mediation. That's really not yet enforceable because it then has to be turned into a property settlement or marital settlement agreement that the court has to approve. So once that memorandum of understanding is turned into a contract, a property settlement agreement, and the court approves it, then it's enforceable as a contract.
And then when one decides, I can't, I don't want to, or whatever what's the recourse? What happens next if there's the breach?
Yeah, it's a breach of contract.
And then?
The court can enforce it.
And so you don't want to do that.
Right.
Be
Yeah.
careful.
And there are certain items in a property settlement agreement that may just be in the property settlement agreement, not part of a court order. So the enforcement of it is by a motion to enforce the agreement. Whereas it were, say, child support, most issues dealing with a child would also be part of the court order. So if the court orders you to pay $500 a month, making that number up again, in child support, and you don't pay it, and it's part of the court order, it's not only a breach of the agreement, but it's also contempt of a court order. And contempt of a court order has more force in the initial enforcement of the agreement out of the gate than the breach of the contract, because first you have to prove there was a breach of a contract, then the judge has to order compliance with the contract, and then if you don't comply with the contract, the court's order, then they can hold you in contempt of that court order. So it's more of a multi-step process.
Sounds like it'd be costly on that end, even though you were saving on the side of being a mediator.
But it's the way to do it.
Let's talk about the money. We don't have much time. Mediation, how much would it cost? And what does the Bar Association do if you need to have it done for low or no cost?
All right, so there's no volunteer mediation program through the bar. There are volunteer mediators. Mediation can either be an hourly cost or a flat fee, and most mediators will meet with you for free and then give you a quote as how they want it to charge you.
So that's a reasonable way to deal with that. If someone is dealing with arbitration, that's a binding thing. That's not confidential, right? That's open.
It depends what kind of arbitration. There's binding arbitration and there's non-binding arbitration.
So that's maybe something that we're going to have to save for another day. Okay. But it does sound like mediation can work. We didn't have time to talk about many business applications of it, but certainly it sounds like that could be helpful too. And let
Same
people.
process.
Sounds good. We hope that this has been helpful to you in making some decisions on how you might resolve your disputes with spouses or businesses. Please continue to stay tuned to The Law Matters. As we say, it matters to you.